where the Act has to be assented to.
Just hours after President Cyril Ramaphosa put his pen to paper and signed the NHI bill into law at the Union buildings, a step which seeks to eradicate inequalities in the country's healthcare system. The DA, however, objects to the bill in its current form.
This bill in its current form will not be able to bring about quality healthcare for all South Africans. It is a lie that has been peddled, and it is simply not true. As the bill stands, all that it will be able to do is to pool funds of about 300 billion rand a year to be able to set up the NHI fund.
The NHI is expected to cover South Africans of all races, rich or poor, and legal long-term residents, narrowing the gap in the standard of healthcare in the country. The DA is of the view that the NHI bill in its current form does not meet constitutional muster and will turn to the courts to challenge it on a number of grounds. This includes the management of the NHI fund.
We believe that the centralization of the pool of funds to manage an NHI fund that will be managed by a minister will not only hinder the ability of people to be able to access healthcare in terms of Section 27, but also will open up the fund to significant corruption.
The DA will also try to convince the courts that the bill will not solve what it terms as the widespread public health crisis in South Africa.
As has become customary, it is now up to us to effectively approach the courts to say this bill will, in effect, be the one thing that will stop people from being able to access quality healthcare in its entirety. The kind of poor healthcare services that we are seeing in South Africa is only going to worsen, and we will be making that case in our court papers.
The DA has 30 days to file its legal challenge. Kani Mapanga, SABC News, Pretoria.